Mr. Green.
And also, my lady, I pretty much finished all the factual matters I was going to deal with ground 5 and obviously traverse some of the other broader points. There are only 2 matters left before Mr. Callis addresses ground 4.
Thank you.
One is in relation to the second claimant and his case. His case was pleaded without any of the examples given by Mr. Blake, such as having to disclose to MHFA and Stonewall and so forth. And so we took the view that it was confined to the immediate Twitter troll abuse on the night and 36 hours thereafter, whichever it was. But shortly before the trial, the bundle E had some additional documents added into it, and can I take the court to one of the examples? It's in S2 at 631. Now, I don't know if Milady has 2 S2 and 3 bundles, or just 1. It's in the second of the 2 if you do.
Right, that's very helpful. Thank you very much.
And it's at the back in tab 7 at 631.
631.
631. And it should say Alf Shufflebottom. And just over halfway down the page, there's a little screenshot of a picture of something going on there. And to the top right of the picture, you can see someone with blonde hair. And that's actually a photograph of Mr. Seymour, because he performs as a very well-known drag artist called Crystal. And there were some very unpleasant responses that followed. For example, the court can see what's written on page 633. But when read, it did invite consideration of what on earth the person's talking about. And a Google revealed that there were later events in 2022 and 2023 of 2 sorts. One was Drag Queen Story Hour, which had proved incredibly controversial in the United States of America with violent riots outside schools, and was also a matter of public controversy in the United Kingdom. Obviously much less aggressive, no violent riots, but and in cross-examination, Mr. Seymour was asked and confirmed. He was asked whether the other people who were drag queens who'd done Drag Queen Story Hour had also received similar abuse, and he accepted they had, and indeed he'd written an article about it. It's all dealt with in our closing submissions. And secondly, the particular article in the Daily Mail was about a performance at Adventure Island, which was a children's adventure park. It was in celebration of Pride, and it was during the afternoon, and Mr. Seymour was there in drag performing, and his genital area was covered with a curved triangular metal plate, and he was holding an angle grinder the wrong way up, so that the handle was pointing upwards and the spinning disc was spinning down towards his genitals. And he was striking the angle grinder on the metal plate over his genitals to generate sparks as part of the performance. And when I sought to play the video of that, to put it to Mr. Seymour, there was a murmur from a learned friend, and then the judge asked me why, and I explained it was relevant to causation, because it appeared to us that what was in fact being done was trying to put in prejudicial material that had not been pleaded late, without us really knowing where it had come from, and to bolster what we thought was a hopeless case on serious harm. And so I said to the judge, it goes to causation. The learned judge accepted that quite properly and repeatedly acknowledged that it went to causation in the transcript. And it was in relation to that performance that these comments had been generated. And so what we had was effectively a novus actus from our point of view, and quite a striking one, coupled with the fact that other drag queens had also received similar abuse. And indeed, Mr. Seymour had written articles saying, for the first time, I feel scared of going to gigs. So that was also relevant and material information. So from our perspective, there'd been a sort of covert addition to the serious harm case, which had been defeated in cross-examination by examining what had actually happened. And can I just say that's the sort of evidence one doesn't forget quickly?
No.
Anyway, it's dealt with at paragraph 102 on page 134.
Of the liability judgment.
Liability judgment.
Yep.
And there was also a Jeremy Vine show interview played as well, where on television, Mr. Seymour said, well, now I'm being abused all because, and it was the recent things, not Mr. Fox. So out of his own mouth. And we thought that was quite important evidence. And 102 at page 134 is where the judge deals with all of that. And it's quite an interesting formulation. Mr. Seymour became embroiled a couple of years subsequently in wider public debates about the suitability of drag entertainment for children in general, about drag artists reading stories to children, about drag shows for mothers and babies, and about his own family-friendly performances in particular. To the extent that any of this caused additional harm to his reputation, then that does not, of course, establish that serious harm was not caused by the original tweets. Well, in its terms, that's true, but it doesn't actually engage with the fact that this was advanced, apparently, to support their case on serious harm and defeated. And then she says, I can see that a question arises about whether this should probably be regarded as a flaring up of the original harm or a wholly independent new cause. That's an issue going to quantum of compensation for consideration at the remedies stage, rather than going for serious harm threshold test. So, on the face of it, she's excluded that from the serious harm that she found to get over to win on liability. And I don't think there's any other way of reading it. I mean, if she's taken into account, it's an error. If she has not taken it into account, all one's really got is the very original trolling. And that's it. Mr. Seymour was a very friendly witness and perfectly amenable to saying, well, I can't really think of any particular things that I've suffered since, lost, opportunities I've lost. So,
did the judge go back to this in the quantum?
She absolutely did, and it's para 24 on page 159.
Thank you.
There she says, I also accept that care is needed in Mr. Seymour's case. over the fact that, as noted in the liability judgment, he subsequently became embroiled in a degree of continuing public controversy about the suitability of drag entertainment for children, both in general and in relation to a particular performance of his own. This controversy was not ignited by Mr. Fox, although he's since engaged in it, including in the context of the present litigation. Well, it was our right to challenge the evidence.
So, what was the engagement that he'd done it? It was simply that you adduced the evidence at trial?
But we challenged it. Well, I don't know if there's anything else. I do know that we did challenge it at trial.
I understand that.
I'm not quite sure what's being referred to. It may be, I think I do know what it's referring to, my lord. I think it was a remark that Mr. Fox made which resulted in the making of the injunction. That was after he lost, though.
Can I understand what you're saying about paragraph 24 of the remedies judgment? Are you criticising that as an approach to this aspect of the evidence?
Well, it was very difficult to see any evidence of any increased vulnerability at all. That was not what Mr. Seymour himself said. All he mentioned was it was triggering if he had to think back to the previous incident with Mr. Fox. I can give the court the...
But just to understand,
Yeah.
Are you suggesting that the judge was here taking into account in relation to quantum? I know you're not on quantum at the moment, just while we're there.
Yeah. Yes, plainly.
This subsequent episode as a
Yes.
piece of evidence of enhanced vulnerability.
Yes.
Yeah.
I think she positively finds that, and that feeds into her award of damages, although it's odd because they've got very different facts and they both get exactly the same figure, but I'll come to that in a moment. So that was C2's claim.
Mm.
So assuming it was left out of account on liability, which appears to, it was just the trolling at the time corrected by Mr. Fox and some national newspapers. And then the only other point, my lords, which I did lay the ground for, but I didn't actually make, was the point in relation to the learned judge's account of Mr. Fox having singled out the three claimants for his response. So we find the three occasions where the learned judge mentions it are at paragraph 95 on 133 in the liability judgment in tab 9 of the core volume. So 97 halfway down, on the right-hand side, and then reacting in such an accusatory manner to some few individuals amongst his surely, if not inevitable critics, etc. So that's the first.
I think the first one is 95 last sentence.
So you're absolutely right.
I have the advantage of doing electronic searches, which is a lot easier.
It is. I've actually just grabbed my non-marked version of the judgment by mistake. There we are. So that's the first. The first one's 95. It says it again in 97, and then we get para 120 on 137. 3 lines down, I've got the right one this time, my lord. These 3 individuals were not alone in calling Mr. Fox a racist because of his call to boycott Sainsbury's, but they were alone in being called paedophiles as a result. Well, pausing there, they were the 3 people that ignited this spat. That's why Mr. Fox responded as he did. Because he was posting something, and as he saw it, denouncing something that he thought was racist and wrong. And they came back and called him a racist for it.
So that last reference again, para.
It's para 120 at page 137.
Thank you.
And then just one last time. The final one, I think, is in para 138 on page 142. And yeah, it's about 7 lines up from the bottom. Mr. Fox had singled them out to call their authors paedophiles in retaliation. So what the learned judge is saying there, which I'll come to after in relation to Mr. Fox's claim, but she's saying there, 6 lines down, right hand margin, even if Miss Latimer's decision, that was the agents who decided to terminate her representation of Mr. Fox, were precipitated by the public prominence of allegations of being a racist in connection with the Sainsbury's affair a month or so earlier. Mr. Fox still has to charge the burden of showing it was reading the 3 tweets complained of, or any of them, that produced the result, and not, for example, the fact that Mr. Fox had singled them out to call their authors paedophiles in retaliation. So, the learned judge appears to be approaching this throughout the judgment on the basis that somehow arbitrarily Mr. Fox randomly selected 3 people to be unpleasant to. And that's actually not the point at all. And when we go back to paragraph 95, that my Lord Justice Warby helpfully directed my attention to, top of 133, others had called Mr. Fox a racist on the 4th of October 2020, and many others had done so all that year in response to his previous interventions on the subject of racism. He singled out 3 particular individuals for the imputation of paedophilia. Well, that's because they attacked him in relation to the Sainsbury's tweet, where he was specifically saying, this is wrong, this is racist and segregation. And they hadn't even bothered to read it. So that is an unhelpful tilt against Mr. Fox that runs through the judgment. My lords, my lady, I'm going to hand over to Mr. Callas, who's going to do the law on ground 4, which should be relatively short, and then I'll briefly deal with the bad reputation and the causation points.
Thank you.
And a 2-second bit on remedies.
Mr. Callas.
My lords, my lady, Lord Justice Green has a saying that good appellate advocacy begins where the skeleton ends. So I'm not going to go in any detail through ground 4 in our skeleton argument. It can be found core tab 3 and the relevant paragraphs of 56 to 75. Fairly crisp 19 paragraphs. That's the summary of our position. Where I do want to start is in an authority which helpfully summarises the intellectual history of an idea. It's Riley, which is in the authorities bundle at tab 26, the liability authorities, tab 26, and we're going to pages 702 to 703.
Paragraph 15.
15, 17. This has actually been marked up by the respondents. I'm be going to it for a somewhat different reason. We'll have to see.
Yep.
This begins with a description of my Lord Justice Warby's judgment in Monroe and Hopkins, which is one of the first Twitter libel trials. And it talks about the context that would be admissible. That was a trial where meaning and serious harm were being done at the final trial together. So meaning was an issue. And you'll see in the discussing of context, my Lord, Mr. Justice Warby, as he then was, drew a distinction between the context that might be admissible on natural and ordinary meaning, and such information that was so far removed that if you wanted to rely on it, it would need to be extrinsic facts pleaded for a reverse innuendo. To be entirely clear, there's never been a reverse innuendo in this case. There probably couldn't have been a stare and campling about third-party publications affecting meaning. It wouldn't have been available. What's interesting is that you can see at the bottom of paragraph 15 that paragraph 39 of Monroe and Hopkins had talked about the context, including parts of a wider Twitter conversation in which the offending tweet appeared. And this is relevant, I'm relying on this not an authority, but almost as an explanation of the pleading to which I'll take the court in just one moment. That approach to context narrows somewhat through a couple of the decisions of Mr. Justice Nicklin, who is the judge giving judgment in Riley. In 16 and 17, he cites his own decision in Hijazi and Yaxley-Lennon, and essentially said that it couldn't be admissible context on natural and ordinary meaning if only some of the readers would have seen it. So in order to be admissible context on natural and ordinary meaning, it had to be material that all readers had seen. In applying those principles, if I could now take the court to the core bundle at tab 21, and the core bundle at tab 21 is it's the decision of Mr. Justice Nicklin ordering the trial of preliminary issue on meaning. He had just made the order saying that such a TPI would happen on the usual issues, and at pages 289 to 293, he gives his reasons for refusing particular directions. The directions that we had sought concerned not only the context that we said would be relevant, but also disclosure, even expert evidence on that context, because we're saying tweets can be seen in different ways. It might mean that we need to get disclosure from Twitter. We may need expert evidence to resolve any disputes of fact between the parties as to how Twitter worked at the time. Mr. Justice Nicklin was not prepared to make that order. And it's fair to say we did not appeal this order. But at 289, he made clear that it was a decision that was a short ruling, although short, is important. He recites the history of the single meaning rule, but I think the important part is to take the court to, is from paragraph 19 onwards.
19.
Sorry, my lord?
19.
Yeah, 19.
19, my
yeah.
lord. I'm so sorry.
The short ruling didn't go to 90 paragraphs, I think. Although some of Mr. Justice Hickman's have been known to do so.
On occasion, my lord. As is made clear in the passages I have quoted from Riley, to be admissible as context, it has to be admissible that was available to all readers. Attempts to partition the readership or group them into particular categories, and to say that some people would have seen the tweet in this particular way, others would have seen it together with this material, is to impermissibly cross the divide between natural and ordinary meaning and the law's treatment of innuendo meanings. The example he gives, and we will go to the pleading in just one moment, is our paragraph 29, which did exactly that. I'm not disputing the characterisation. At paragraphs 21 to 24, which I would ask the court, when it retires, to read those in full. We say it's very, very important. He essentially says, the matters that the defendant has sought to reduce as context on natural and ordinary meaning cannot be done, for the reasons I've said, but there's no unfairness in that. Because all of the points that they want to make about how the other material that I've excluded from context would affect the way that readers understood it, all of that can be dealt with in serious harm at the final trial. This decision was, quite probably, not appealed. The context for the TPI was limited to the immediate tweets themselves, because nothing else would pass the rather higher test in Riley and Hijazi than we say was operative under Monroe and Hopkins. And so the very limited context at the TPI, and indeed in this court on appeal from the TPI, was limited to just the tweet. The tweet, the whole tweet, but nothing but the tweet. In short, the context at the TPI that generated the single meaning as a matter of law was a context in which not one single reader actually read the tweets. It's an entirely artificial context because it deprived them of anything else in the conversation that they would have seen, even if what they saw was hugely variegated. Turning to our amended defence, which is also in the core bundle at tab 17, I'd like to go, if we may, to page 26. Page 26. I'm so sorry.
Internal pagination or?
No, it's the core tab 17, forgive me. I think I've been looking at the internal tab number. Core tab 17, and it will be page 211. This is the paragraph which Mr. Justice Nicklin had quoted in his judgment. And it talks about the different contexts which had been pleaded. Mr. Justice Warby and Monroe and Hopkins had said you need to plead extrinsic facts for an innuendo. Similarly, you should have to plead your context for an actual ordinary meaning. So that's what we had done. It was pleaded at paragraphs 29 and 30 as context, with a view then to paragraphs 31 to 35 being our case on meaning. Subsequently, there's an amendment, but to reflect the change of context of Mr. Justice Nicklin saying all this belonged in the serious harm trial, serious harm is moved, you can see as a heading above paragraph 31. So this was squarely the different ways in which it was read, the confounding information, the different media articles. This was squarely part of our case on serious harm. What I want to explain about this case being somewhat out of the norm is that the normal run of cases where an inference is drawn, and may often be drawn, from a very serious imputation, perhaps in the natural and ordinary meaning, and very large scale of publication, itself rests on two implicit assumptions that very rarely themselves break the surface. The first of those assumptions is that the actual meaning or meanings taken by readers are at least proximate to the single meaning. So it might be that the single meaning as a matter of law is a chase 2 allegation. There'll be some reasonable readers who would have said it was closer to 1, some who say it's closer to 3, but they're all broadly in a range. This is an unusual case where the meanings are, I think my own friend Ms. Green said, polar opposites. But there's almost a binary meaning. You either believe that it's a paedophile meaning of fact, or you recognise the rhetorical point being made. The idea that the single meaning is at least proximate to the actual meanings is what generally allows for, as part of the stage of reasoning, the usual inference to be drawn. The second implicit assumption is that to some extent, that meaning is believed. There's only one case, I think, in the world that really talks about belief. It's actually Lord Neuberger's decision in the Hong Kong Court of Appeal in Oriental Press. For my lordship's and my ladyship's note, that can be found at Authorities tab 11.
I think there's also Riches.
My lord has the benefit of me, I'm sorry.
Case where 11 members of the Banbury CID were accused of wrongdoing. They recovered about £250 in compensatory damages and £25,000 in punitive damages, indicating that the jury didn't think that anyone took it seriously, but they thought it was a terrible thing to say.
I see. Well, I'm grateful for my lord's example. The cases on either of these are, I think it's fair to say, vanishingly rare, because obviously before 2013, the issue of belief only went to damages, as in Oriental Press. But at least that deals with belief. Now, the criticism, which I'll come on to make good, is that when one reads the learned judge's judgment on liability, there is at least some recognition of the submission that the second implicit assumption is problematic, on credibility and belief. She recognises there are some portions of the audience that don't believe it, thus their support for the claimants. She recognises that it may be that no one believed it in the single meaning, but they might have believed it at some lower level of suspicion. She does at least make some degree of engagement with the second implicit assumption, but we say there's no engagement with the first, which is the extent to which you can reliably say that publishees actually understood the words in the single meaning. And to give one obvious example of why they wouldn't do so, anyone who read the defendant's tweet against the third claimant with the mimicry that the Court of Appeal found was obvious would recognise the rhetorical device. If they see the defendant's tweet to the first claimant, second claimant, and the third claimant, they see all three of those tweets together. No reader who was reasonable could persist in the idea that this is three independent allegations of fact. They would have to, if just from the mockery directed at the third claimant, they would have to recognise the rhetorical point he was making. All of the media articles in the days that followed cited all three. It cannot be said that anyone who learnt of this, but not being on Twitter, but learnt of this through the media, took the single meaning. In fact, we say the only available meaning for them to take would be the meaning that we had contended for unsuccessfully at the TPI, because of the difference in context. And this is why this case is so different to the normal run of cases. The normal run of cases might be a newspaper article like Le Show, where there isn't much dispute about the context at all. Everybody agrees the context in which the exercise of meaning should be conducted, and there's very little that would vary that. It might vary it a little on chase level, but probably not beyond that. This was a case where the single meaning only arises if you don't have any of the confounding material that we say we tried to bring in as context, but ultimately we were then told had to be brought in on serious harm. We tried to bring it in there and it's not dealt with. A point then about Le Show. Le Show is such a familiar authority. There's a danger in conflating what its ratio actually is as opposed to what it approved on the facts of the particular case. Le Show is at authorities tab 25, and the judgment begins at page 682.
In the liability bundle?
Liability authorities, yes, Michael. The first three paragraphs of Royal Assumption's judgment are introduction, facts. And I'm looking at subheadings here. Paragraphs 4 through to 9 are the common law background. Paragraphs 10 to 20 are the important part of the judgment. They are resolving the rival constructions of section 1. And paragraph 11 makes that very clear. The one construction was that serious harm was about the objective tendency of the words, as the Court of Appeal had found. The rival construction preferred by Lord Assumption was that advanced originally by my Lord Justice Warby, in the first instance, that it was a matter of subjective fact, albeit reached through an inference. But they were the rival constructions at para 11. The resolution of them is at paragraph 20. We say this is the ratio of the case. The Court of Appeal's analysis not only gives little or no effect to the language of section 1, it is to my mind internally contradictory. Davis LJ, who delivered the only reasoned judgment, accepted the submission on behalf of Mr. to show that the seriousness of the harm caused the claimant's reputation by the publication depended on the inherent tendency of the words. But he appears to have thought, para 70 to 73, that where this was serious, the result was to set up an inference of fact which it was open to the defendant to rebut by evidence. As Ms. Page accepted this will not do, the common law rule was that damage to reputation was presumed not proved, and the presumption was irrebuttable. The common law rule survives, there's no scope for evidence of the actual impact of publication. That is the main reason why, in my opinion, it cannot survive. Davis LJ has, with respect, accepted the legal analysis advanced on behalf of Mr. Le Show, while attaching to it the consequence of the legal analysis advanced on behalf of the newspapers. In my opinion, Warby J's analysis of the law was coherent and correct for substantially the reasons which he gave. The remainder of the judgment then looks at the application of the law, section 1 properly construed, and the way it had been handled by Mr. Justice Warby at first instance, and says there's no basis whatsoever to interfere. I would just say parenthetically, it somewhat stops short of injuncting all courts to draw inferences from the single meaning. It doesn't go that far. That wasn't the type of judge that Lord Sumption was. But he found nothing to interfere in the way it'd been done. But the ratio of the case, if nothing else, is paragraph 20, which is that you cannot set up the inherent tendency of the words in the legal fiction of their single meaning as a rebuttable presumption. If it's serious, it creates a rebuttable presumption that then it's for defendants to rebut as a matter of fact. That's the ratio of Lachaud.
Perhaps on that point I can intervene to explain my earlier reference.
Of course not.
My judgment in Lachaud, paragraph 59, page 358 of the authorities bundle, makes a point that a claim, well, one consequence of the interpretation that was upheld may well be that a claim will no longer succeed where the meaning is a serious one, but the claimant's reputation in the eyes of those who read the words complained of is not in fact harmed seriously, if at all. That was the proposition, and the two cases cited were Rich's and News Group newspapers and Oriental Daily Publishing.
I'm grateful for
That's
concluding this.
another advantage of electronic searching.
So we say if one turns up the respondent's skeleton argument, there's one paragraph in particular that we do take issue with, which is paragraph 76 of the respondent's skeleton argument, which can be found in the core volume, tab 4, page 77. Where they say, in response to the appellant's contention, it's for the claimant to prove, for the purposes of establishing serious harm, the words were actually understood by readers in a single meaning and were believed by readers in that meaning, the two implicit assumptions that I've referred to. The court has consistently taken the view, and this is the key word, including since Lachaud Supreme Court, that it's the defendant, not the claimant, who bears the evidential burden involving substantial publication, if he wishes to put that in issue. Now I say, that's exactly what Lord Sumption at 20 is saying is not the case. It's not that you check if the inherent gravity of the single meaning is serious. If it is, that sets up something that then the defendant bears an evidential burden of rebutting. Serious harm, the legal and evidential burden, stays with the claimant throughout. This is not a reverse innuendo case. It's not for us to call evidence, especially in what's been described as a mass publication case, to rebut. The question is whether the inference is safe in the first place, given the two implicit assumptions, the first of which hasn't been addressed at all. I would just cite, just by reference to the index of the liability authorities, the first case cited is Al-Saifi, which in our authorities comes at tab 19. Lachaud in the Court of Appeal comes in at 80. Deere and Sadler, cited by them next, is at tab 20. These were cases from the interregnum, when the Court of Appeal's rebuttable presumption was good law. So any reliance on those cases, I think the same would be true of Doyle and Smith, which is a decision of my lords. Those cases were about rebuttable presumptions because they precede the Supreme Court decision in Lachaud. For the ones that they say come after, including the TPI in this case, we say those cases do not squarely say that the evidential burden falls on a defendant, and we say if they did so, they would be contrary to the Supreme Court in Lachaud. And so, in respect of the court judgment itself, at tab 9, there is a passage, just for your lordships and your ladyships note, between paragraphs 80 and 96, where the judge does occasionally stray into issues of credibility and belief. But nowhere does she deal with the pleaded case, moved in response to Mr. Justice Nicklin's directions to the TPI, into serious harm. Nowhere does she deal with the case of whether there is a safe inference that can rest on most of the readers having actually understood the words in their single meaning. Because we say all of the ones who got it from the media couldn't, all of those who saw more than one of the tweets couldn't, all those who saw the Twitter conversation about libel claims couldn't. All those who saw language is powerful, which went to exactly the same audience as the defendant's original tweets, even though the algorithm now sends you tweets from people you're not following. All the people who saw the apology, all the people who heard talk radio or LPC. There is possibly a hypothetical possibility that, like the Japanese soldier discovered in the 1970s who didn't know that the Second World War was over, that there might be one hermit who managed to only see one of the tweets in no other context and avoid all other countervailing information not only to the date of issue of the claim form the following April, but all the way to trial, avoided the TPI judgment, which confirmed it was baseless, or the Court of Appeals judgment. But even if you had such a reader, on the statistics, the relative scale of publication of the defendant's tweet and the "here we go" tweet, for example, just like the abuse pleaded in support of C1's case, it's more likely that that abuse or that publication occurred by reason of the claimant than by the comparatively limited reach of the defendant's publication. My lords, my lady, oh yes, just to be clear, it's not just readers of the Daily Mail, but even publications such as Pink News. All of the media includes all three of the tweets. It can't possibly be that readers who saw all of that would take the single meaning. We say they take our meaning, but it isn't our case to prove. The claimants would have to show that that first step of the inference is safe, that people who had the context that was excluded from the TPI would nonetheless have read it in the single meaning. We say no one reasonable who had access to the context excluded from the TPI could have read it in that way. My lords, my lady, unless I can insist further.
Thank you very much.
Thank you.
Mr. Green.
Lords, my lady, I'll be reasonably brief. We've developed much of this in our skeleton fairly extensively. The first issue is the law on general bad reputation. And there's a short way and a long way of doing it. I'll do the very short way first. If you read any fair reading of the judge's judgment, shows you that read together, the paragraphs that don't announce a finding of general bad reputation, unless together clearly make one. And that's really what she's done, and it's wrong. But it does obviously require a little bit more care than that. Can I just begin by asking the court to look in the core bundle, please, at paragraph, page 266 in tab 18. That's tab 18, page 266. And there we have further, and in the further alternative, C's will rely upon general bad reputation as a race.
What are we looking at here?
Sorry, this is their reply and amended defence to counterclaim.
So you're on paragraph 33?
33.4
Yes.
on 266.
But we need to look at this in context, don't we? You'll come to it, I'm sure, but the bad reputation point is the fourth of four.
Absolutely. Yeah. So, in fact, my lord, the context, I think, probably properly first takes root at 254, at paragraph 28.3, which was the material I've already taken the court to, that I've already mentioned to the court at least, as having been added. Sorry, I haven't taken the court to this, I don't think yet. No, sorry. D, 28.3, D had been described publicly as a racist before the date of publication of C's tweets. For example, D had been so described following his appearance on Question Time in January 2020, following and in response to the announcement he was setting up a new political party, and in response to tweets by D, now deleted. Now,
And then we get a number of examples.
we get a number of examples. And that was what I think I did mention, that this came from 15 examples. Now, these were added in, and they appear to either advance a case on general reputation as a racist, or, and I'll come to the exception, the rule in Dingle in a minute, and they could be trying to identify a specific cause of a specific event relied on by the claim, by Mr. Fox. Now, the paragraph 28 just pleas, the chapeau of 28 says, as to paragraph 80, it's denied the publication of any of C's tweets has caused or is likely to cause serious harm to T's reputation. No admissions are made to the subparagraphs of 80 except otherwise set out below. And 28.2 is the expression of opinion, which later finds expression in the judge's decision, as we know. And then 28.3 is all these examples. And we then get 33.4. Now, that's denied on page 279 in the following tab, tab 19. And it's denied at 20.3. And it's denied, it says, it's an impermissible plea of general bad reputation. The very sting of the libel sued on, yet the claimants are not permitted to rely upon other publications under the rule in Dingle, and the defendant has no relevant convictions or civil judgments against him capable of supporting such a plea. In circumstances where the first and second claimants are not even pleading a defence of truth, such a plea is also an abuse of process. It basically does a proxy truth attack. And so it was a pleaded issue before the judge as to whether there was Mr. Fox couldn't recover on because he had a general bad reputation. Now, what's said in the skeleton on page 52 of the core bundle?
Whose skeleton?
The respondent skeleton.
Yeah.
Is the respondent says that we should have known that that was not an issue because it wasn't in the list of issues. It's paragraph 19. So they accept that there was absolutely no way that at 18. They say it was not pursued at trial, second line. However, it was not pursued at trial. Mr. Fox and his legal team must have realised this by the time trial started. It had not been obvious from the fact respondents served no witness statements from witnesses who would be called at trial to prove Mr. Fox possessed a general bad reputation. Evident, the only way it can be done subject to proof of criminal convictions and the like. It should have become obvious the respondent's skeleton argument at the trial oral opening where no such case was advanced. Now, the only slight qualification to that is the pleading that I just showed the court. If we can just go back, please, to page 266. The list of issues was prepared on the 2nd of November, which if one wants to, one can see in the index to SUP 4 on page item 21. And if we look over the page at 267, we can see that this pleading was dated the 6th of November, 4 days later, and very shortly before the trial began. So they'd actually doubled down by adding the words and afterwards 33.4 on page 266. Now, this is a damages...
I rather thought it was in your favour that they were saying it wasn't an issue at trial, and the judge seems to, according to you, decided the case on that basis. Now you're saying it was an issue at trial.
Well, my lord, all I'm saying is that we've had a finding against us where it looked as if they were not pursuing it.
Yeah.
There was an unhappy lack of clarity. If you amend a few days before trial to say you are pursuing it because you add an extra twist to your case on general bad rep, it's not helpful, shall we say. And the point is that what we did not want to happen was exactly what did happen, which was a sort of covert version of a finding of general bad reputation, which is what we get in the judgment.
Where?
So we've identified in our skeleton argument, we've sort of summarised this, and at ground 1A on page 21, and if we look in the judgment itself, yeah.
In the liability judgment.
Yes. So we cite the relevant passage of Bates at 13, having identified the pleadings at paragraph 12 of our skeleton. We make the point at 15 about not seeking to prove the specific libel. It's a rule in Dingle I'll come to. And then we've identified the relevant passages mainly between 143 and 157. They're the paragraphs identified in a paragraph 18 of our skeleton on page 22. And we quote 157, choices about the exercise of your free speech rights have reputational consequences in real life because they cause other people to form or change an opinion about you. So that seems to be saying that other people's opinion about Mr. Fox had been changed.
So, which paragraph in the judgment?
157,
Yeah.
which we find on page 147.
Yeah. So the first sentence of that.
Exactly.
Yeah.
And we respectfully say that when one reads the way in which the learned judge actually rejects the apparent causation of Ms. Latimer's termination of agency from 136 onwards, but actually it starts a bit earlier. If we start, just to give the court the relevant context, 132 on page 141, looking at first principles. 133, she says, that from the evidence, or for example, on the evidence shown to me, Ms. Latimer might have concluded, objectively, a word she repeats throughout these paragraphs, that question time affair was not after all an isolated incident, it was going to blow over if he kept a low profile for a bit. On the contrary, she might have concluded Mr. Fox was set on a trajectory, etc. Might have reached a view about his lack of insight. None of this was actually put. Lack of insight. She reached a view that you had no insight, didn't she, Mr. Fox? No. So none of this was put. So the judge has said it's not her job to speculate. So in 132, 5 lines down, an inch in from the left-hand margin, it is not my job to speculate further about Ms. Latimer's view of Mr. Fox. It's his job to persuade me of them. And then there's a long passage of speculation that leads up to 140, or the conclusion in 139, about all the reasons that Ms. Latimer might objectively reach adverse conclusions about Mr. Fox. Some of them are not relevant to some of his more outspoken positions, but a fair reading of the judgment, including that which we've identified both at 157 and also and the bottom of 156, but the choice of methods for doing so is reputationally relevant in itself. So it's absolutely clear on a fair reading of that section. I hope the court will understand, but given limited time, I'm not going to did deal with it in extenso. But a fair reading of that treatment, together with what she says about Mr. Fox at the beginning of the judgment, where she lays it all out, it is effectively finding, on a purely speculative basis, that there was a substantial body of opinion that thought he was a racist. And that was not evidenced, certainly unsafe, insofar as there was any evidence of that at all.
There was no evidence at trial from Miss Latimer, is that right?
She did not want to give evidence.
No.
And the learned judge reminded herself that in defamation cases many people don't. But her assistant did. Mr. Fox's assistant did.
It's not an evidence. No, it wasn't an evidence that she didn't want to. It was an evidence that it appears not to have occurred, or it was on legal advice that he didn't call her.
Well, she didn't give evidence.
She didn't give evidence. So she didn't give evidence, but Mr. Fox's assistant gave evidence at the time, and it's difficult to see how the learned judge reached the conclusions on causation that she did, because she leaves out of account the fact that it's difficult to see why the speculative ideas about question time, etc., can possibly be right when we have Ms. Latimer in January saying back to after the question time events, I'll give the court the reference, she responds in an email of the 18th of January 2020 after question time, which you can find at S19133, and one compares this with paragraph I think 133 of the judgment. She writes back and says, "Oh God, I'm so sorry. This whole response has been ridiculous. Let me know if there's anything I can do, XX." So the judge not only does speculate based on impermissible evidence of bad character and breach of the rule in Dingle, which I'll come to briefly, does speculate based on that evidence, which was A, not representative at all, and B, in clear examples contrary to the primary evidence, documentary evidence at the time. So what actually happens is that after question time, Sue Latimer is extremely understanding, in fact very supportive, thinks the whole thing's ridiculous. They have correspondence, and on the 2nd of October, Sue Latimer is offering Mr. Fox a role.
You showed us that this morning.
Yeah, 2 days before the event in question. After those events, there are other things still coming in, and he forwards one on the 11th of November to Sue Latimer, something that's come from America. She's his agent. And the next day, on the 12th of November, she terminates. And he simultaneously tweets that she's terminated, stopped being his agent, and without identifying anything racist that he's ever done. That's what's said at the time. And the difficulty the judge had was, although she was recited that Mr. Fox had to confront normal tort law, she did not have any regard to material contribution. There is no common sense way you can rule out by pure speculation of material which we contended was clearly in breach of the rule in Dingle, rule it all out entirely in those circumstances, having made any material contribution.
And does the judge make findings of fact on what the assistant said?
Yes. Ms. Kowalski's evidence is identified at... she starts in 138, 122. She says, "It's a startling feature of Mr. Fox's case. I have no witness evidence from Ms. Latimer as to why she parted company with Mr. Fox. The authorities on defamation do counsel caution in deference to the difficulty complainants may have in finding people prepared to say they thought less well of them and support their case. But it's no secret Ms. Latimer dropped Mr. Fox, and the only question would have been why. I do not have her answer.
Well, that's Miss Latimer, but she
Yeah.
recites what the
Yes.
evidence was from Miss Kowalski. What did she say about
And-
she
she slightly
what findings she
sidesteps
made
it.
about it?
Yeah, she says she deals with the contemporaneous tweet internally Mr. Fox made on para 130. Got dropped by my acting agent for being racist this evening. Asked for evidence, none provided. And then we get Miss Kowalski at, sorry, 1 second. Can you give me the power? Miss Kowalski. So I just lost it for a second. No, in the judgment. Actually.
125.
Sorry?
125.
1, 2, oh, sorry, yes. Thank you very much. I had my hand over. Thank you very much. Great, this page. Assistant also testified. So 124 is the assistant said that she had overheard a phone call between the two of them to that effect on the 11th of November. No contemporaneous record of this conversation. Mr. Fox's own evidence was that it was the second instalment of a conversation, done earlier that day. The vast majority of business transacted took place in the first phone call, which he described as distressing and upsetting. Mr. Fox's assistant was not asked to recall the overheard second part of the phone conversation until a couple of years later, and in the context of this litigation. She was plainly anxious to do her best to support Mr. Fox and assist him in this matter. But her account was not unambiguous. She referred to unease in Miss Latimer's team and to coverage of allegations of racism, neither of which leads directly or specifically to these three particular tweets themselves. I mean, there is a obvious temporal bite, which is surprising to wave away so lightly. The assistant also testified to having been aware of media coverage adverse to Mr. Fox in the immediate aftermath of question time, and the reports he lost work as a result of that, feeling that he was being accused of being a white supremacist. As she put it, she told me she's not familiar with the detail of the acting side. No mention of Ms. Thorpe or the claimants by name been made on the call. Generally, people were not being nice to him on Twitter. Well, not being nice on Twitter was then.
I think the nub of the judge's assessment seems to be at the very end of 125.
On the next page, my lord.
Yeah.
Yeah.
She doesn't regard Ms. Kowalski's evidence as being as significantly advancing the case of Mr. Fox.
Yeah. And normally one gives quite a generous approach to the judge's impression of witnesses, but it, we say, may not necessarily be appropriate in this case generally or on this issue. Because there are so many contemporaneous markers that it's difficult, and the whole thing is set aside later by a process of unjustified speculation. We say that that's not an appropriate way to deal with that issue. As to the rule in Dingle, there is we've dealt with it on page 23, ground 1B, bar skeleton, that's C323, between paragraphs 22 and 29. I would ask the court just briefly to look at page 187 in tab 14 in the core bundle. This is the learned judge's refusal of PTA, reasons for refusal. And paragraph 5 on 183 on serious harm, the learned judge says there was no material dispute at trial as to the relevant law or underlying facts. At least acknowledging there was a dispute about the inferences. And then if we go forward to 187, we've got, 185, we've got the groundless imputation of singling out. I've taken the court to that already. And then the one on Dingle is at the top of 187, error of law, causation, and the rule in Dingle. The rule in Dingle was not cited or argued before me in relation to either liability or damages. And so it's not only pleaded in the defendant's reply to the defence of the counterclaim in paragraph 6 at page 269 to 70 in the same bundle. So paragraph 6 says facts and matters in 28.3, which are the ones I just showed the court. I haven't taken the court to those actual tweets to show you the pathetically low numbers of likes. I mean, and there's no national news story around them at all. Some of the likes are 3 likes. There's some are more, but I haven't done that exercise. But over the page, the rule in Dingle is expressly cited with the full case citation, and Wright and McCormack is also there. It was in our trial skeleton at paragraph 111.2a. This is all on page 25 of our skeleton. Entry number 20 on the joint chronology, which is bundle 4, tab 8, page 157. That matters because that was a joint chronology the judge asked us to provide for her in the closing days of the trial. That was live. And there's a massive red, highlighted, red and bold reference to Dingle and that material being not agreed because it breaches the rule in Dingle. It was also in our closing submissions 172, and it was also actually in the Claimants. Claimants also cited it. There is, I think I'm going to have to rely on the skeleton as I'm coming up to 3 o'clock in relation to those matters, unless there are particular ones to mention. Safe to say, just in relation to the contention by the respondents in their skeleton at paragraph 15, which is in the core bundle at page 52. They say the respondents do not dispute the account of legal principles on general bad reputation and proof at 10 to 21 of the appellant skeleton, save to this extent. But it may be that there was no presumption of good reputation at common law, and even if there was, it's now been abrogated by the enactment of Section 1 of the Defamation Act. And that cites Wright and McCormack, where my Lord Justice Warby at 51 says that there is a presumption of good character. So I'll see how that's developed. I may need to respond to it, but we respectfully say that good character and damage are analytically different. And the fact that there was previously, before the 2013 Act, a presumption of good character and presumed damage does not mean that when presumed damage is abrogated by statute, presumption of good character is abrogated. I think, true to my word, I hope that's 3 o'clock on the dot. I don't know if I can assist with any particular.
Thank you very much. Ms. Page.
My lady, I'm going to start with the counterclaim, and specifically, in that regard, going to be dealing with what my learned friend has just covered, which does, I think, I suggest, bear a certain amount of unpacking in terms of what were the issues and what were the facts which the judge had before her. The starting point I wanted to give was by way of a standing back on the counterclaim, starting with the appellant's skeleton argument for the way in which they put the case on serious harm to his general reputation. Can I invite you to go to paragraph 7 of his skeleton argument? It's page 20 of the core bundle. And the skeleton starts off with this statement. There is no doubt, nor any dispute, that in the days and weeks following publication of the Claimants' tweets, the defendant acquired a reputation as a racist, and that his reputation by that point in time had suffered serious harm. That is a tendentious statement, we say. We've made the point in our skeleton argument, because it treats as if it was or is undisputed, and not merely as beyond doubt, which is obviously mere submission, that Mr. Fox acquired a particular adverse reputation following publication of the claimant's tweets. Now, that is an incorrect statement if its purpose was to inform the court about the scope of the dispute at trial. It was very much in dispute that whatever reputation, negative or otherwise, Mr. Fox had, there was no evidence that it was, as it were, acquired as such after, let alone by reason of the claimant's tweets. Now, if one drops down to Mr. Fox's skeleton argument, paragraph 9, same page, page 20, there's an encapsulation here of the three parts, as it's now put on causation. I should say, by way of general remark, before I draw attention to the bits of it, that the case at trial, and it appears not to be challenged, that this was the judge's interpretation of it, that the way in which he sought to prove that he had acquired a serious reputation following the 4th of October was because of the termination by Miss Latimer and then the fall off in career. So this wasn't actually presented as an inferential show case, although that's how it's dealt with by the judge. It was very much, this is the proof. The proof is that my agent dropped me. But when we look at the skeleton argument, it's put a little more broadly than it's characterised without challenge by the judge. And it said that there are 3 points to Mr. Fox's case on causation, in respect of all of which the judge erred. And the first one is the general harm to his reputation, such that a significant portion of the population now consider he can legitimately be called a racist. So I invite attention to the words now consider, which takes us right up to the point of the trial, and that he can legitimately be called a racist. So on this formula, Mr. Fox identifies, as he did at the trial, he identified his acquisition of a reputation as a racist by reference to or by the measure of people calling him a racist. And he asked the court, he put before the court, the occasions when on Twitter he was called a racist after the 4th of October. And he produced what he had found in the exhibit to his first witness statement. Now, for some reason, we appear not to have that in the bundles, but I think I can summarise it uncontroversially. The relevant section of his exhibit to his first witness statement comprised a series of tweets on the, which is 4th of October, which is where the compilation started, of other people, not the claimants, tweeting on the 4th of October that he was a racist in connection with his tweet about Sainsbury's. So when the judge says there were others, but these were singled out paedophile. There were others, and I'll come back probably tomorrow when I've been able to talk to Ms. Grossman in the light of what was said today, that on the face of it, but I need to check this, other people's tweets on the subject started before the claimants. Now, that collection then carried on down to 2023. And so what he was saying is look at the occasions when people have called me a racist since 4th of October, and that is a measure of the fact that people now feel they can call me a racist, and that is a signifier that my reputation has changed. Now, to which the claimant's response at trial, I'm going to ask you to look at the statements of case a little bit more closely than Melanie Friend did. The claimant's response at the trial was to say, but hang on, you were being called a racist before 4th of October 2020. In other words, in exactly the same format. But in that case, prompted by your own public interventions prior to the 4th of October. But on this appeal, Mr. Fox is saying that pre-4th of October denunciations of him as a racist are legally out of bounds, because he says this is an attempt to establish general bad reputation by the back door and contrary to the rule in Dingle, both of which, of course, are about mitigation of damage, not about causation of the damage, the specific damage he relied on, as to whether or not he had suffered serious harm. So the pre-4th of October history, that by these points of law, he seeks to have rules in this court inadmissible, are the specific prior statements by people to the same effect as the libel, and the specific incidents of the public interventions by Mr. Fox, which is what had caused those denunciations of him as a racist before the 4th of October. So what we have is, since question time being when, on his own evidence, paragraph 13 of his second witness statement, he said he suffered a tsunami of abuse, we have a continuum from question time onwards, down through and beyond the 4th of October. And you cannot just look at what that continuum from 4th of October onwards and say that is a demonstration of serious harm without looking at the first part of that continuum. So the pre-4th of October history was relevant for two very obvious reasons. Firstly, whether Mr. Fox had in fact suffered a serious adverse hit on his reputation by reason of the publications of the 4th of October, as measured by his very own metric of the abuse he suffered before the 4th of October, and if there was an increased level of abuse, he says he suffered after 4th of October, and if so, whether that evidenced a sort of cliff face, serious harm to his reputation at that point. And that, of course, is all very much an issue. Secondly, the history is relevant because the events of pre-4th October provided alternative causes of or explanations for the denunciations of him as a racist and for the specific career setbacks that he says manifested themselves in the period following the 4th of October. Now, I started with critiquing paragraph 7 of his skeleton argument as tendentious, but paragraph 7, on the face of it, also puts in issue the reasons why Mr. Fox might have attracted denunciations as a racist right up until now. But on this appeal, he also seeks to say that any public interventions of his on the subject of racism after the 4th of October were also legally out of bounds, to which we say, how could they be out of bounds? They obviously were relevant to whether, if he was being denounced by others after 4th of October, were the probable reasons for that interventions on his part, or were the probable reasons for that the three expressions of opinions by the claimants had brought that about? And of course, for that purpose, you had to look at what the denunciations after the 4th of October were. And if I might just characterise the position now, that the racist denunciations that he disclosed and relied on in his witness statement after the 4th of October, apart from the odd one which references that there's going to be defamation action, none of them on their face have anything to do with anything that was tweeted by the claimant, or anything to do with the claimants having generated it. A number of them are denunciations because of his arrangement of the pride flag into a swastika, for which he was suspended from Twitter, his tweeting that a black footballer charged with rape, take the knee, you fuckers, I think it is. These are all there, but the sheer quantity of them is no different to the quantity beforehand, namely the 15 tweets that were introduced and which are in play, and which I'm going to demonstrate were in play at the trial. Now, moving on then back to paragraph 9, the skeleton argument as the convenient source of the other two sources of harm, albeit I say that the agent was the one on which he particularly hung his serious harm. As he puts it at the top of page 21, two interrelated specific forms of harm flowing from, and importantly evidencing, the general serious harm to Mr. Fox's reputation being, so the decision of the agent to terminate and the drying up of offers. Now, what was not in dispute was that 5 weeks after the 4th of October, Twitter spat, Miss Latimer terminated her agency representation of Mr. Fox, and of course, depending upon Miss Latimer's reasons, that is of course potential evidence that Mr. Fox did have at that point a negative reputation in the eyes of Miss Latimer. And as for the falling off of acting offers, the Annex 1 schedule to Mr. Fox's trial skeleton argument purporting to evidence that was also not challenged for what it said on its face. In other words, the accuracy of the information was not challenged, but of course on its face it could tell the court nothing about why the factual situation shown had occurred. So of itself, Miss Latimer's termination says nothing directly about when any lowering of his reputation in her eyes took hold, in her mind, or why. And why might, of course, have been an accumulation of different factors over a period of time. Even if there was sufficient circumstantial evidence to support a conclusion that Mr. Fox did acquire a reputation as a racist in her eyes, his case at the exact point in time when he acquired that reputation in her eyes was upon publication of the claimant's tweets, and that was absolutely disputed at the trial. That is what he was being put to proof of. Now, the judge pointed out something uncontroversial at paragraph 49. I don't think it's necessary because to turn to it, it's page 122. I'll just read the relevant relevant bit. I am in a moment going to be toing and froing between the judgment and the skeleton arguments. But what the judge said, which I submit is uncontroversial, is this: the harm of defamation is the effect of a publication in the mind of a third-party publishee, and thereby on a claimant's reputation, and not on any specific action adverse to a claimant the publishee may take as a result. The test does not require the demonstration of adverse actions by publishees, although such actions may be powerful evidence of the state of the publishee's mind. Now, the adverse action of Miss Latimer did, of course, in terms of chronology, come after the claimant's tweets, albeit 5 weeks after. This was referred to as a coincidence of timing at the trial by Mr. Fox, but the judge, in refusing permission to appeal, described that argument of timing of coincidence being a very weak point evidentially. But as to when Miss Latimer's mind changed about Miss Fox, assuming it did change, that evidence, of course, had no visible date or dates stamped on that change of mind, because Miss Latimer was inexplicably not called as a witness. And the explanation given, as I sought to clarify earlier, was that he had legal advice not to call her. Nothing was said about her willingness, or nothing was in evidence about her willingness or otherwise. And Mr. Fox invited the inference that the change of mind suddenly took hold in Miss Latimer when she read the claimant's tweets of 4th of October, although there was no direct evidence that she had read any of their tweets, or if she had read or read about the back and forth exchanges of 4th of October, no evidence whether what brought about any sudden change of mind about him, if it did, was the claimant's expressions of opinion that he was a racist, or his own contributions to the back and forth of 4th of October. On the face of his tweet, calling for a boycott of Sainsbury's, he was calling on it because of their support for Black History Month. That was the statement of Sainsbury's that he reproduced. You didn't find anything about safe spaces to connect with his comment about segregation unless you clicked on the link in his tweet. And even on Mr. Fox's case as the law, and I quote now from the last sentence in paragraph 22 of his skeleton argument, if the claimant relies on a specific event as proving serious harm, and then jumping over, the defendant is permitted to rely on previous publications as being causative of that particular event. And the specific event he's relying on as proof of serious harm was the termination of the agency relationship. But the fall-off, which is a specific event, the fall-off in offers of work, on which there was much less emphasis in the trial, because obviously it would have been affected by having no agent, was equally a specific event. Now, if we go now to a passage in the judgment, it's at page 141 of the core bundle, paragraph 131. This is what the judge concluded about the oral and documentary evidence around the termination by Miss Latimer. At 131, she says, this evidence, and she was referring there to Mr. Fox's messaging after the termination, which I'm going to ask you to look at because that was in evidence before her. This evidence, like that of his assistant, suggests the reason Ms. Latimer let him go was to do with racism, but it does not make any visible connection with the tweets complained of. Indeed, it could be read as an indication that he understood he was dropped for being racist or for generally being called a racist, rather than having been so described by anyone in particular. And of course, for the reasons that I'm going to go on and explain, the fact that he was generally being called a racist from question time onwards was in evidence before her, and it was admissible. It was objected to, but I will show you in detail what form the objection took. Now, as the judge who heard the witnesses be cross-examined and read the documentary evidence, she found the evidence around the termination of the agency inconclusive at best. In the absence of Miss Latimer being called as a witness, the judge, in fairness to the claimants, surely had no choice but to be careful and subject to scrutiny the self-serving evidence on that subject of Mr. Fox and the evidence of his assistant, who said that she overheard the relevant conversation, or one relevant conversation on those, apparently two on the relevant day, but she wasn't asked to recall it until earlier in 2023, so over 2 years later, and there was no contemporaneous record of the conversation itself, so no note made by the assistant or Mr. Fox at the time. Now, the judge does not, of course, have to give, I submit, a blow-by-blow account of all the reasons why she found the oral and documentary evidence falling short of proving Miss Latimer's mind was turned by the claimant's tweets. It is true that this particular judge, unlike some others, does not tend to quote lengthy passages of cross-examination and then comment upon them. She distills, that is her style, and one sees it in her judgments generally. She distills her conclusions, but she does so in a way, I submit, with such detail and subtlety that it's apparent that nothing that has gone on in front of her has been lost or overlooked. But although she hasn't done it in relation to the documentary evidence that was relied on, I'd like to take one sample from Mr. Fox's evidence, which was part of the overall picture provided by the oral and documentary evidence that Mr. Fox now says she should have found to be probative. So I'd like you, first of all, to set the scene. I'd like you, first of all, to go to Mr. Fox's skeleton argument, paragraph 48.2. I'll give you a page number on that. Well, the paragraph 48 starts at the bottom of page 29, and this is in the section on plainly wrong. The judge's conclusion is plainly wrong. At paragraph 48, two further pieces of evidence supported the defendant's case on causation. The first one, 48.1, Mr. Fox's oral evidence. That Ms. Latimer referred to 4 allegations of racism made against me by someone in showbiz, making the girls in the office feel very uncomfortable. And I should say that that didn't appear in either his first or second witness statement. That only popped out of him in cross-examination. He was challenged on why it wasn't in his witness statement, because it would have been, one would have thought, rather an important bit of evidence. And then about Sue asking me whether it would be a good idea to spend some time off the books. Now, it's 48.2 that I wanted to invite you to, which is where Mr. Fox criticises the judge's treatment of the email that he wrote to her on the 30th of September 2020. Now, she reproduced that in full at paragraph 126. I don't think it's 127, which is what's the reference in paragraph 48.2. But the oral and documentary evidence around the 4th of October contains the 30th of September email he wrote to her, as well as, of course, the offer that she forwarded to him on the 2nd of October. Then the oral evidence of the conversation back in, down in November, and what he then said about that phone call at the time. So if I could just ask you to cast an eye down, because in 48.2, this is the explanation as to why the judge failed to draw the right conclusions from the email of the 30th of September. Now, after the conversation Mr. Fox says took place between him and Miss Latimer on the 12th of November, he sent out a tweet, and the judge refers to this at paragraph 129. And the tweet is at 5:42 p.m. immediately after. It seems to be an issue about whether this was 11th or the 12th, but either way, if I say 11 or 12, it's one of those days. 5:42, immediately after the calls, Mr. Fox tweeted out, "I want to thank my acting agent who let me go on the phone just now for reaffirming exactly why I am doing what I am doing. Still waiting for a single example or anything I've ever said or done that could ever be deemed racist. We will reclaim freedom, fairness, and common sense." And at 130, she, by the way, if one wants the reference to that tweet, it's supplemental, well, we don't need to look at it, it's supplemental bundle 1, tab 67, page 250. And then at 130, the judge referred to some contemporary messaging that was in evidence before her between Mr. Fox and some contacts of his. And I do ask that we go to those. We have them at supplemental 1. They start at tab 68 on page 351, and I want to look at a few pages of that.
Sorry, where are we going now?
Sorry, supplemental bundle 1.
Yep.
Page 351,
Thank you.
electronic, and tab 68. Otherwise. So at page 351, he is messaging on the night of the 12th of November, evening 12th of November, got dropped by my acting agent for being racist this evening. I asked for any evidence, none provided, and there's an exchange, you okay, and so on, 22 years, a job I loved, just and they were wrong. Of course, one must bear in mind that this is 5 weeks after this huge storm around the events of 4th of October. But not a mention here that this was something that the acting agent had cited as being the reason, and one would have thought that if she had said or implied anything to that effect, that might be writ large on his messaging. The next page, 352, is a message he sent to Miss Latimer herself that evening. It simply says, "I have never once said or done anything racist. In fact, quite the opposite. Remember that. Good luck in the future. Goodbye." Again, no reference at all to the events of the 4th of October. And then at 353, this is, it starts off, this is to same evening, 6:13 p.m. Laurence Fox message, "Got dropped by my acting agent for being racist this evening. I asked for any evidence, none provided." And then there's it's just crazy. I mean, you pest, it's the worst. What a bunch of cowards. Can you find another agent fast? So you look like you're fine, even if not. So in other words, advice to get another agent. I don't want one. They're all the same. I'm sure, but just so you keep that option open for yourself and for public perception. So this is the optics, presumably for his career, of not having an agent. True, but I'm getting a huge wad of cash for this game, that we understand to be as leader of Reclaim, 250,000 a year, I think it was. And I suppose it's better to be hated and rich than hated and recently fired from Asda. Now, there's not hated by my agent, hated generally. Quite true, but still I think you should keep the option open as much as you can and make sure there isn't a perception that it's closed and so on. And then there's another one at 354, and then the one I wanted to particularly draw attention to is at 355, at tab 73. And this is a little bit later, 8:56 p.m. And Mr. Fox is messaging the contact, thinking about how to make positive my serious anger about being dropped by my agent for racism. And the contact called Andrew says, but I thought they dropped you ages ago. I remember you telling me. And Mr. Fox replies, formally. Andrew, so the same person? Yes. Coward. Andrew, I'm confused. So since they canned you months ago, they since took you back. And Mr. Fox then leaves a voice note, and I'll just read out what the voice note says. The voice note has him saying, my American agent started sending through scripts, because we heard about that from earlier. So it sort of reignited the conversation again, I think is what happened. But so cowards nonetheless. And then Andrew, okay, I get it. Thank you. Now, I'm going to comment on that in a moment, but since we have this, my lady and I operating on hard copy bundles, tab 80, which is page 375, while we are here, this is slight digression, but just to check to not have to open this bundle again so deep. This is the Reclaim Party website. The Reclaim Party, the soft launch was, I think, 27th September 2020, so on the eve of the, that's when it all came to blew up as launch. And at page 376, this is what the website says. Laurence Fox set up the Reclaim Party in October 2020 after appearing on BBC Question Time in January that year for challenging the woke orthodoxy of white privilege and systemic racism. He was cancelled from a 22-year acting career. This experience changed Laurence's life overnight, and now he is dedicating his life to protect others from being prevented from contributing to the national debate. So you put that bundle away, and I want to go back to, so you were canned before by your agent. I want to go to the transcript. So these files are really big and bulky. And for the transcript, cross-examination of this is bundle 5, volume 1 if you're in hard copy, tab 5, page 242.
242.
242.
Thank you.
So, page 224, it's, so transcript pagination, page 224, line 13, and Miss Skinner takes him to that exchange with a friend about being canned. And at line 17, you can see there you were saying to your friend, think about having positive my serious anger about being dropped by my agent for racism, yes. And Miss Skinner says, not because there are allegations of racism being made against me, but for racism, yes. He replies, that's what I wrote, yes. And she says, I suggest you wrote that because that is what you were told by your agent. No, that's not what I was told by my agent. We've already gone over that. And then Miss Skinner quotes, but I thought they dropped you ages ago. I remember you telling me, and you have put formally, so the same person, yes. And then you called her a coward, right. Is that her you were calling a coward? Yes. And then your friend says over the page, I'm confused. So since they canned you months ago, they since took you back. And then there's the voice note gets played, and dropping down to page 226 of the transcript, can you help us with what the reference to canning you months ago was and taking you back and then reigniting? And he replies, I think what I'm referring to, what time of day is it anyway that this conversation is taking place? 9:20 at night. So I think what would have happened was, there was obviously a blip with Sue sometime in September, when we were writing to each other, and I was saying, stick by me, stick with me, that sort of stuff. And then she continued to send scripts. So I would have obviously seen that as a blip. But I would probably have spoken to him at that point and said, look, I don't know if this is going to work. They're going to get rid of me or something. And the question is put to him. So the reference to being canned is a reference to the September blip, yes. And the answer, yes, I'm just trying to put it in my own head, to get it in my own head right, because scripts did still carry on arriving. That's all. So they obviously didn't fire me, otherwise I wouldn't have still been getting scripts. So this is then my commentary, things were so bad for him at the time of that email of 30th of September with Sue Latimer, that at the time of writing, he thought he'd been fired by her, and he had told his friend at that time that he had been fired. And this is all just before the Twitter spat of the 4th of October. So we can put that bundle away. And yet the judge is now criticised for having failed to hold that the claimants' tweets in their own right caused such harm to Mr. Fox, his reputation in the eyes of Miss Latimer, that his reputation effectively fell off a cliff and caused her to terminate the agency relationship 5 weeks after those tweets. Whereas Mr. Fox was forced to admit in cross-examination that he thought he had lost her as an agent in September 2020, at which time she was a coward then and a coward later. A coward because she didn't have the stomach to represent him, I suggest, in the light of his public stance since question time. And then I ask this rhetorically, how, in fairness to the claimants, just taking that one piece of rare contemporary documentary evidence that was available at the trial, coupled with his email of the 30th of September, how could the judge, in fairness, have held the claimants responsible in law for Miss Latimer terminating his agency agreement? I mean, the idea is just completely unrealistic. And the consequence would have been they would have had to pay compensation to him for having lost his agent.
This was part of his case on general damage, wasn't it?
Yes.
There was no financial loss.
No, exactly, yes. But they would have compensated him for the loss of reputation.
I don't know if anyone's ever referred to Section 1, Subsection 2, but this was a Section 1, Subsection 1 case throughout.
Absolutely, yes.
That's the way you're presenting their case.
Yes.
Loss of the agent as evidence of damage to reputation, sounding in general damage.
Yes, exactly, yes. So he is then without an agent. His contact, as we saw, is stressing the need to get another agent because of the optics of not doing so. And Mr. Fox says they're all the same, all agents, all the same, so I'm just going to get rich as leader of the Reclaim Party. And then we see the story on the Reclaim Party website about after he found it after question time, having been cancelled from a 22-year acting career. But Mr. Fox's problems didn't end with the inconclusive or worse than inconclusive nature of the oral and documentary evidence on which he relied around the agency termination. If the evidence before the court showed that there were other candidates for having caused or contributed to the agency termination, in other words, candidates that viewed objectively and rationally were potential candidates, and of course these candidates were all being put to him and canvassed in the submissions, then if there were such candidates, the claimants were entitled to have the court take them into account before fixing liability for the loss of the agent and the fall-off of acting offers on the claimants. And of the various potential causes or potential explanations for the agency termination and career decline, firstly taking, for example, an important example, Mr. Fox's own public interventions on the subject of racism, from question time onwards, which, and I gave the reference earlier, it was his second witness statement, paragraph 13, he said provoked a tsunami of abuse. But it also included his Sainsbury's boycott tweet, which attracted denunciation of racism on Twitter by a number of others, not the claimants. So the relevant question for the court was this: was that conduct on his part, viewed objectively and rationally, capable of having had a causative role in the specific harm of which he complained? If yes, then the judge was entitled, indeed bound, to take that conduct into account, because the claimants could not be held liable for any contribution to the specific harm that was self-inflicted by Mr. Fox. And obviously, if the answer is no, then of course she wasn't entitled to take them into account. But that's the correct question. The answer was plainly yes. His prior conduct, including his conduct on the 4th of October, was obviously capable of damaging his career. And according to his exchange with his contact on the 12th of November, he believed that his career was already damaged goods in Miss Latimer's eyes as of September 2020. On top of which, there were before the court admissions by Mr. Fox that the views he expressed were unacceptable within the acting industry. And in his own article, he wrote for The Spectator, published on 20th of June 2020. I'll just give the reference. It's Key Supplementary Bundle, tab 11, page 65.
Sorry, supplementary bundle, which one?
Key Supplement. Oh, is that not what yours
Okay,
is?
we're 1, 2, 3 or 4.
We do have a key supplement, right? Well, I do.
Oh, I do.
Completely.
There was, pursuant to Master Meach's order, there was a sort of selection made of key stuff from the 5 volumes.
Well, I've got it electronically: 1, 2, 2 and 3, 4 and 5.
I need some help because I'm not
We'll
working
find it.
electronically.
It's okay, we can just give us a
It's supplementary reference 1, tab 15, pages 153 to 158.
So SUP 153. Shall we just look at it just to ensure that we can all make sure we've got it?
Yes, I've got it in a different bundle. So I'll
Well,
look at
that may well be.
yes, yes, I'll look at it in the bundle. I've
SUP
got.
153.
Yes. Or yes. So this was, if you have that, this is an article written by Mr. Fox.
The pitfalls of wrong think.
Yes, the pitfalls of wrong think, and it's published on the 20th of June.
2020.
20th of June.
Yeah.
Sorry, 2020, yes. It starts off with first they came to the statues, then Basel 40 got cancelled, and so on. But the relevant paragraph, I mean, the whole thing is relevant, but the particular paragraph I'm referencing is the second paragraph of the article. I too have come to the conclusion that I may never get an acting job again without expressing correct opinions. While this probably isn't the end of the world for you, it is a cause of some sadness and anxiety for me, not least because I have two children who need dinner and clothes and a holiday once in a while, and so on. So that was one of the passages. Then there are other admissions, and they are catalogued by the judge in the section of her judgment that runs from paragraph 17 to paragraph 31. I'll just go to paragraph 17, sorry.
Paragraph 17.
17, yes.
Yeah.
So this is the section in which he is setting out the profile of Mr. Fox in 2020. I haven't, certainly from the skeleton argument, understood there to be any challenge to this as a fair account. But at 17 to 21, she recounts what happened at question time at 17 to 19, to 20, to 19 at 20, paragraph 20, there's an interview in the Daily Telegraph on the 2nd of October. He said of his subsequent political project, the acorn possibly got put in the ground after the question time explosion, and then it grew, and then she refers to the Reclaim Party homepage. Then she refers to another intervention, Mr. Fox's paragraph 21. That's not about whether it's in terms of his acting career. Going to paragraph 22, this is a reference to an appearance on ITV's Good Morning Britain, and he was pressed about certain comments he'd made on the podcast that's referred to in the previous paragraph, and Mr. Fox said, as you've noticed, I say quite a lot of unfortunate things, but I think it's really important that one is able to express one's opinion, and people should not be terrified to feel what we say. And then just dropping down to the bit the judge picks out, he was asked if he thought his career could be affected by his recent comments, so talking about January 2020. He said, we'll have to wait and see. It added, but does one want to work in a career where you have to have the right opinions? I don't. I don't think art is going to be improved if everyone has exactly the same opinion. And then she cites then the fact that equity, paragraph 24, a few weeks after the Actors Union, Equity put out a statement denouncing Mr. Fox and his political views on racism as a disgrace to our industry. His remarks on question time have been criticised by Equity's minority ethnic members committee, threatened a lawsuit, and he obtained a retraction apology, but the apology was removed and equity refused to reinstate it. And then dropping down as far as 28 is where she cites the pitfalls of wrongthink, the Spectator article, and she cites that his statement, he might never get an acting job again. And just a paragraph dropping down to 30, she records that he continued to speak out accordingly. His public comments continued to attract media attention, and his Twitter fellowship steadily built through the late summer. So that, I want to draw attention to that there were these admissions before the court of the impact of his own public interventions on his acting career. And it's the specific harm to his acting career that he seeks to lay at the door of the claimants. But more than what I've highlighted so far, there was no dispute at trial that the court had to exclude any self-inflicted element of the harm when deciding whether the claimant's tweets had contributed to the harm, and if so, whether any contribution in fact made by their tweets amounted to serious harm, so in other words, added serious harm. So with that introduction, I want to go on to look at parts of the statement of the case and the written submissions, specifically because of this. In order to get an appeal before this court, Mr. Fox's case has effectively had to recast the exercise the judge was engaged in of evaluating, amongst other causative factors, and in the light of his admissions, in the light of his email to Miss Latimer, whether the claimant's tweets played any materially causative role in the specific harm complained of, as an exercise on her part in finding he had a general bad reputation. That is how he has had to characterise it, as an exercise in mitigating damages, which they then, of course, complain offends the rules as to proving general bad reputation. Now, just to put one's finger on where this is done, if we go to Ms. Fox's skeleton argument, paragraph 17 on page 22, what he says is an error of law on her part. The judge erred in relying on specific incidents where Mr. Fox had made public statements to conclude that he had a general bad reputation, and implicitly that he deserved to have a bad reputation, so that his claim failed on causation. This was both wrong and unfair. Now, the judge, I submit, did no such thing. It's obvious from the story that was going on in front of her and from her judgment that she did no such thing. And the same applies to the question of whether statements by third parties adverse to Mr. Fox's reputation prior to the specific harm were potentially causative of that harm, which on this appeal, Mr. Fox now seeks to characterise, or did, I'll come to the characterisation trial, but seeks to characterise for purposes of appeal as a breach of the rule in Dingle, although acknowledging in his skeleton argument, as I pointed out earlier at paragraph 22, that it's not a breach of the rule for a defendant to claim to rely on third-party publications as causative of specific harm. And at paragraph 23 of his skeleton argument, on page 23, Mr. Fox challenges parts of the judgment at 145 and 148 as demonstrating the judge's disregard of the rule in Dingle. And the impugned quote from paragraph 145. This is a merger of parts of 145 and parts of 148, the paragraph 23, and the cut-off line is where there are 3 dots. So after vanishingly small, that is the end of the quote from 145, and I'm not satisfied as the beginning of an extract from 148. And what the judge said, if you look at page 145, contains some words that...
Page or paragraph?
Oh, sorry, page of the judgment is...
144.
144.
But it's paragraph 145.
Paragraph 145,
Yeah.
page 144. So in the impugned quote, there is omitted his own tweet, 4 lines down, his own tweet, Mr. Fox's own tweet on 5th of October in the aftermath of the Sainsbury's affair, which had been only the latest occasion of a quantity of such allegations, confirmed he had been, quote, repeatedly, continuously, and falsely smeared as a racist. And he told Nick Ferrari on 13th of October he had had, quote, several months of being called a racist. And so she concludes, that is why she concludes, the inherent probability in these circumstances that it was the particular tweet sued on here that changed anyone's mind or affecting Mr. Fox's career must be vanishingly small. I mean, that is a statement that in the light of what he said on the 5th and the 13th of October, straight after the tweets, must be completely open to her as a conclusion. So in the light of these statements, what weight, I ask, could the judge in reality have placed on Mr. Fox's case on general harm to his reputation, articulated in his skeleton argument at 9.1, as I pointed out on page 20, such as he, to quote, such that a significant proportion of the population now consider he can legitimately be called a racist.
You're quoting there from the appeal skeleton.
Skeleton argument.
I think you told us earlier that you were going to take us to what was said at trial to explain how the judge approached the matter.
About yes.
Yes, so you're taking us to the judgment before you get to the pleadings. I mean, speaking for myself, it would help to understand the basis for your argument that Mr. Fox's case was put on the basis that specific responses were the general harm to reputation that he was complaining about and nothing else. Because I hadn't understood it that way. You're saying all of this material went in legitimately because he was complaining about specific responses.
Yes.
And you cite the well-established principle that that's okay.
Yes.
Until you said that, I hadn't understood that was his case.
Right.
So it would help to have that
Yes.
explained.
Well, I'm going to go to the pleadings.
Yeah.
So I think that will help. So the starting matter are on the pleadings. I want to go to his particulars of serious harm to begin with, which I think we didn't. I'm not sure that we did see. But it's core bundle tab 17, page 230, paragraph 80. Oh, sorry, I've got the wrong bundle. Page 230, paragraph 80, sorry. Slow with the bundles. So, particularly of serious harm, paragraph 1 reflects that his own case acknowledges the need for him to be able to isolate the harm. Now, paragraph 1, he identifies a problem with isolation of the harm, which is confined in paragraph 1 simply to the claimant's 3 tweets inter se. But obviously it applies, as I'm sure he would have accepted, to any other factor in play that was potentially causative of harm to reputation. So isolation of harm is an exercise that both sides agree is what we are all about when looking at his case on serious harm. Subparagraph, so we've got then the extent of publication, gravity of the single meaning, circulation, publication, no takedown. And then at paragraph 7, it's his case in the second half of that paragraph that in the Twitter sphere, so first of all he's saying these allegations will have stuck, this is particularly serious harm. It sets out his dissension from current popular ideology, and the last 5 or 6 lines, in the Twitter sphere, it is not unusual for people such as the defendant who publicly dissent from those ideas, not least because those ideas in themselves, which are based on unfounded generalizations about people on the basis of their skin colour, appear to support a racist view of the world, to be publicly denounced as racist, and for those allegations to percolate into the mainstream. So in other words, he is accepting that he lives a life where he conducts himself with the risk that he's going to be denounced as a racist.
Sorry, this is just a question about where we are. I've lost publicly.
Sorry,
it's the end of paragraph 7.
End of paragraph 7.
Yeah, thank you. Sorry.
And of course, the metric for harm relied on by Mr. Fox for his reputation having been damaged by the claimant's tweets was that he was subject, after 4th of October, to racist denunciations of him on Twitter. Then, subparagraph 8, in this case, as a consequence of each of the claimants publicly and unapologetically accusing the defendant of racism and refusing to retract the allegations they made, the false idea that the defendant is a racist and that it is acceptable and justifiable to accuse him of being a racist have become accepted and mainstream. So he's saying that, in effect, he's saying that justifiable or acceptable to accuse him of being a racist kicked in after the claimant's tweets. So it's obviously relevant to see whether that was true or whether the denunciations of him as a racist had kicked in long before, which indeed they had, as we'll show. And then he introduces other people calling him racist. He says, although there were instances of people on Twitter calling him racist before the claimants did so, those were isolated tweets with very little engagements. The claimants were the first to make these allegations to tens of thousands of people. This has emboldened many more individuals to accuse him publicly of being a racist, believing they're entitled to do with impunity. The defendant will rely on all the many occasions he's been accused of racism since the publication of the words complained of, and will give disclosure of the same at the material time. So he says, he tries to distinguish, in order to make good his case on causation, the previous instances when he was denounced as a racist on Twitter with what followed afterwards. And he says, well, you know, that they had very little engagement. But in actual fact, the tweets after also had very, very little engagement. Some of them no engagement at all that he put in evidence. And we'll see in a moment that he only relied on 2 Twitter publishers, in there. But pausing there, first of all, it is clearly he is making, he is acknowledging, he's putting in issue the scale of third-party publications of racist accusations against him prior to publication, in order to point up a comparison with the scale of such publications post-publication, in order to make the case that he had suffered additional harm to reputation by reason of the particular tweets of the claimants, which, although in the same vein as he had been subject to before and was prone to being subject to his knowledge, was to many more followers. But of course he had to persuade the judge that this additional harm to reputation from whatever contribution these 3 tweets among pulled out from other tweets on the 4th of October made a contribution, an additional harm to reputation that was serious additional harm. So he needed to provide the judge with a basis for concluding that the claimant's tweets caused that additional harm, and that meant that at trial he would need to help the judge understand how she was to arrive at a conclusion that the claimant's denunciations in their own right, as she put it at 150, caused additional harm to his career. So in this pleading, he's not merely, I stress, giving permission to the claimants and to the court to examine for purposes of causation the reputational impact of third-party publications before and after 4th of October, but he is trying to preempt an argument on causation by the claimants that their tweets did not cause him additional serious harm. So he's acknowledging that he has to show what was different about the claimant's tweets as against the other racism denunciations he had previously received. But it also means that there had to be an examination at the trial of the reputational impact of other sources of racist denunciations, and there also had to be an examination of his public interventions in order to establish what may be the cause, on his case, of substantial post-publication denunciation of him as a racist.
I'm not sure that follows. We're straying rather from across 2 boundaries, aren't we? There's the case on general reputational harm, which starts off with a purely inferential case, and then moves into this specific case about pre and post denunciation for racism. Then the pleading moves into loss of his agent. And your case on that is, and the judge's findings are not limited to racism. They're limited. They encompass all sorts of factors. So we're straying into across the boundary into different territory. And then you say, and all of that justifies examination of the reputational consequences, which is another sector altogether, or it goes back to the first. So I think one's got to be a bit careful about the definitions.
Well, the problem is that this is all put at trial in very much on the basis that the measure that he had suffered serious harm were the career consequences, the loss of his agency, the fall off in offers thereafter. The inferential case is not prominent at all, I suggest, in the way it's put at trial. And the reason is obvious, because he was attacking the inferential case of the claimants. Because he didn't like the inferential case approach, and it couldn't be and wasn't seen or understood clearly by the judge to be advancing a freestanding inferential case. His case was tied to the termination of the agency and what happened to his career subsequently. It was not a freestanding inferential case simply on the Lachaud factors. But she did go through that exercise all the same.
It's in the written guys and submissions. I mean, I don't know what
We'll come back tomorrow. And then moving on in his particulars of serious harm, in paragraph 9, and he cited just one example of the post-publication denunciation of him as a racist, which he says it starts at 9 and goes on for
So subpara 9.
Subparagraph 9
Yeah,
of paragraph 80 at page 231. One instance of a note for republication is that of Ms. Liz Tray. So she's around 1,100 followers. On around 14th of April, 1 week after the claimants had issued their claim form, she tweets, and then it sets out what she tweets. It includes that he is a racist, and then she subsequently accepts that allegation is untrue. But what she tweets and what she was threatened with illegal consequences for doesn't say anything about the claimant's tweets, doesn't say anything about Sainsbury's boycott, doesn't say anything about paedophile allegations, doesn't say anything about the claimants having issued their claim form. And we are talking about months after the events of the 4th of October.
The claimants issuing their claim, that's dealt with later on though.
I can't remember exactly.
81 subpara 4.
Yes, they issued their claim form around this time, but she makes no reference to this. April, yes, but she's not making any reference to it on the face of it.
Okay.
And then the wrap up of paragraph 11, he seeks to place responsibility on the claimants for a wacky letter received on the 30th of April the following year, offering to sell him guns and grenades from someone called White Wolf. Absolutely no visible connection with the claimant's particular 3 tweets, or racism, although he invites an inference it's to do with racism, and then 2 episodes of feces put through his door. So his case is that these incidents inexorably point to the claimant's tweets as having triggered these events. So it was obviously relevant for the judge to consider whether there were other potentially causative factors in play, and that is exactly what I submit the judge did when she took the long view at paragraph 151 of the judgment, where she didn't need to, and she says, insofar as the long view is thought to assist on this issue, and as we saw, he was claiming that the damage was continuing to occur because the claimant's tweets had unleashed an ongoing entitlement of people to feel that they could call him a racist. And so she lists some of them so she talks at 153, she talks about the intensifying trajectory of controversial public interventions by Mr. Fox on the issue of racism. These included tweeting out an unreferenced and uncontextualized excerpt from some song lyrics, including 2 uses of the term nigger, the incorporation of a picture of a pint of milk into his Twitter profile, a symbol with some recognised connections to white supremacy, which I was given no convincing explanation, a flowing with blood tweet about racial unrest in the UK, a tweet showing a black footballer, and so on, up to, and I've already mentioned the swastika, and the showing himself photoshopped with a black face in response to the Mayor of London. And some of these, the nigger one I think is in 2020, some of the others are, another one, some of them are in 2021, some in 2022, some in 2023. And I see the time, I don't know whether that's
Well, we're rather in your hands on that.
yes, I think that I was wondering whether I should just keep. Can I just carry on a little bit more on the pleadings? I'm just that you normally write.
Of course.
4:15, just for a few more minutes while we're on this pleading.
So still in paragraph 80.
Yes, paragraph 80, and then so paragraph 10, he's saying that the claimant's allegations will receive very wide publicity as a result of the publicising the Twitter dispute. The media response to this dispute so therefore contributed to the damage to the defendant's reputation and not the claimant's. Now, there's one more tweet that he cites as evidencing the harm, and that is Mr. Mukhtar. Sorry, I can't find it. Where it is. Forget Mr. Mukhtar for the moment. Can we then very quickly go down to the defence to the serious harm claim? And that is in tab 18, page 254, the same bundle. So paragraph 28.
Sorry, page.
Page 254.
Thank you.
Paragraph 28 is a response to paragraph 80. And this is where paragraph 28.3 comes in. So this is in a section about causation of serious harm. And it's in response to a pleading that there had been denunciations of him as a racist prior to the 4th of October, not on the same scale. And the response to that at 28.3 is to list the 15 occasions that they had found in which the defendant had been described publicly as a racist, as he has himself pleaded, before the date of publication. And so, for example, the defendant had been so described following his appearance on Question Time in January 2020, following and in response to the announcement he was setting up a new political party. And those range in date from 2nd of February 2020 right down to the 27th of September 2020, so right down to the tweets, and the later ones are connected with the launch of the Reclaim Party.
And they're pleaded as examples, but they were the only ones.
They were the only ones that were
I
put in
gather.
evidence. But,
Yeah.
but on top of that, there were all his admissions about tsunamis of abuse and repeatedly smeared for months and so on.
Yes.
But those are the ones that are attacked as breaching Dingle.
And they,
But this is
you
not.
say they were there to acknowledge his admission that
Yes.
there were such tweets,
Yes.
and then to do what?
And then to demonstrate how harmful they were, the reputational consequence, the contribution that they were capable of making to what subsequently happened to his career. In other words, insofar as he says, the harm to me is measured by me being denounced as a racist after 4th of October, and those denunciations are evidence of harm. We demonstrate that he had inflicted harm himself on his own metric, which may be and certainly capable of being probative of the career consequences that he suffered and the impact on Miss Latimer's mind. Now, I need to say something a bit about then the challenge of the 15 tweets, and that will take me a few minutes. So can I suggest that I resume that tomorrow morning?
Thank you very much. So you're 10:30 to 12:30.
Well, 10:30 to 12:30, but in my case, I'll sit down before 12:30 because Mr. Pasuto is going to deal with damages.
Thank you very much. And then you're 12:30 to 1. Good. Well, thank you very much indeed for all the help. We'll look forward to seeing you at 10:30 tomorrow.